begin from here. As the Finance Ministry prepares to, in collaboration with the Ghana Revenue Authority and other allied groups, begin deduction of the E-Levy from May this year, critics say there must be commitment to accountability. For a lecturer at the University of Ghana Business School, Professor Lord Mensah, the controversial levy has come to stay, urging people to brace up for it. The finance lecturer also believes nothing will come out of a suit by 3 minority MPs challenging the passage of a law. He spoke on News at 10 with Martin Isidati.
Effectively, we're going to get that sensitivity as to the patronage going down as a result of the price that is being charged. But for me, I think we've gone beyond that kind of back and forth where we were thinking about the bill being passed or not. We have to look at it as a bill that has come to stay, and because I've heard my minority going to court, but then I don't think anything will come out of it because the budget in itself was rejected. But then when it went to court, I mean, unanimous decision, it was approved. It was 7-0. So I don't think anything new will come out of it. Something that.
Well, the debate as to whether a quorum was formed in Parliament before the passage of the E-Levy is continuing to rage on as the minority has expressed its intent to seek redress. In fact, they have filed a suit at the Supreme Court, 3 of the minority MPs, that is. The basis for this controversy is founded on the Supreme Court's interpretation of Justice Abdullahi versus Attorney General case, in which it's described the 138 MPs form a quorum. We also know the injunction placed on the Asin North MP James Quayson at the time of a passage excuses him from playing his role as a parliamentarian. Now, this raises fundamental questions as to whether the injunction placed on him reduces the total number of parliamentarians by 1 at the time of a passage of the E-Levy, and whether that reduction technically reduces the total number of members to form a quorum from 138 to 137. Joining us is private legal practitioner Vitus Bang. Thank you for joining us. So can we say the injunction placed on the Asin North MP technically affects the total number of parliamentarians in the House, taking into consideration the day the E-Levy was passed?
Good afternoon, Comrade, and good afternoon to all our viewers across the world. Thank you for the opportunity. Indeed, I would say that the injunction placed against the Asin North MP will not affect the quorum requirements imposed on Parliament by the Constitution of Ghana, particularly 104 clause of the 1992 Constitution, which is the supreme law of the land.
Okay.
The said provision says that except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of all the members of Parliament present. So the issue of whether there's an injunction against the Asin North MP does not, relate to the issue of the quorum requirements. The quorum requirements relates to the constitutional architecture on how many members of Parliament do we have. We have 235. So half of that will be 138. And it doesn't matter that a member of Parliament has been injuncted. And I'll give a scenario. For instance, let's assume that, God forbid, all the, let's say 10 or 15 MPs are not in Parliament for any reason at all. Either they resign or they pass away, God forbid. Does that mean that we're going to reduce the total number of members of Parliament dictated by our laws by 10? No. The constitutional provision is there to serve as a check on Parliament, and in appropriate cases, it means that Parliament will not be able to go ahead with any business of the House if their numbers fall below the constitutional quorum requirements. And may necessitate, in appropriate cases, a by-election or what have you before a decision in Parliament may be made.
Okay, but then the question as the minority have raised is that even as it stood at the time, the House did not form the required quorum, for which reason they are even in the Supreme Court at the moment challenging the passage of the E-Levy as we speak. So then where do we draw the line then? 138, 137, or any number below that?
I would think that 138 was required because as I have read the provision to you, it says that at least half of all the members of Parliament must be present before a decision is made. Now, the Constitution and indeed the Supreme Court in the Justice Abdullah case recognizes two quorum requirements: a quorum for Parliament to convene, and then a quorum for Parliament to vote on an issue or to make a decision. Now, the first quorum is easy to meet, in that one requires that at least 1/3 of all the members of Parliament must be present, 1/3. Okay. But the quorum for decision making is that at least half of all the members of Parliament must be present. So I don't think that the issue of the Aston North MP reduces the quorum requirement by 1.
Okay.
It is still 138 in my candid opinion.
Okay. Thank you, private legal practitioner Vitus Bande. We await the Supreme Court's determination on this matter as by 3 members of Parliament, Mahama Yariga, Minority Leader Haruna Idrisu, and North Town MP Samuel Okujeto Blakwa.